So for this lecture, we're going to be now building on the material from the previous two lectures that talked about the legislative, executive, and judicial branches and what they can look like in terms of the diversity of forms and the kinds of choices that need to be made to actually create these different systems. In this lecture, we're going to examine the sort of institutional arrangements that are necessary and possible. And again, as I've said a lot of times, this is going to give you a sense of the diversity, but there are many more options that are available that I'm going to actually explore. There are possibilities beyond the three-branch model, as I will talk about in the final lecture for this module. So just know that this is a development on the first two lectures, but that there's, as always, sort of way more that could go into designing a democratic system of governance with separation, sharing, and blending of powers. To start, we should just note that the government exercises power across the entire range of a multi-stage policy process, and this is something I've discussed already. And here's the very simplified three-stage process. In the beginning, there's make policy and set budgets, and then implement and oversee policy, and then judge, interpret, and evaluate. And then, of course, this is a cycle. It doesn't. It's not just a simple movement from left to right. It cycles back into an ongoing policy process. This simplified model, though, is kind of very helpful because it shows us that there are some pretty significant categories that the policymaking process can be divided into without sort of missing out on what's going on. And the reason why this is useful is because typically in designing a democratic system of governance, these different stages are distributed across different institutions in different branches of government. And that's what we're going to look at today. The question that we have, of course, always is how are the powers and responsibilities in this process distributed among institutions and office holders? And you've already gotten a sense from the first two lectures in this module about how that happens. Now we're going to sort of zoom out and take the big systemic look. How is it integrated into a comprehensive system of policymaking? The traditional three-branch model is based on the fundamental notion of separation of powers, that the policy-making process has these distinct stages that are best given to separate branches of government so that, one, they can specialize and do a better job of each stage, and two, so that the different branches can check the power of each other. So there's a dual movement of empowerment and restraint built into the traditional three-branch model of separation. And here it is: legislative, executive, and judicial, and it goes left to right. The legislative branch makes policy, sets budgets, and then takes part of the second stage of overseeing policy, watching the executive branch to make sure that its implementation of policy is being done according to the lines that are set by the legislature. The executive implements and evaluates policy, and once again you can see that part of what it does is grab from the next stage in the policymaking process, the evaluating part. And part of what the evaluating does is it provides feedback back to the legislature in terms of making future policy and setting budgets. There's an input loop that goes back in that direction. I don't have an arrow here on the diagram because I don't want it to become too complicated, but the evaluation that the executive branch does is partly geared, it's partly geared towards making sure that the executive can kind of report back to the legislature to improve the ongoing policymaking process. And then, of course, the judicial branch is largely in charge of the third stage of judging and interpreting. There is some evaluating that goes on there as well. So each of those major stages, with a slight sort of step over into the next, is what the traditional three-branch model is built on. And I will repeat it again because I think it's worth noting that there's a dual rationale here: empowerment and restraint. Separating the policymaking process into different institutions allows each institution to specialize, and by specializing, to be both more efficient and more effective. Now, separation is really only one part of the story of institutional arrangements in a democratic system of governance. Before I move on to sharing, I have to note that federalism adds a second layer of separation where the three-branch model is separated into two levels, or even more levels. It could be national, state, and local. And some powers are exercised exclusively at one level or the other, and some concurrently by different levels of government. So in the U.S. federal system, the federal government exercises certain exclusive powers: power to coin money, power to conduct foreign affairs, power to run the military. And many powers are exercised concurrently: the power to tax, the power to make criminal laws, the power to set up and run a judicial system. So separate federalism is essentially a form of both separation and sharing. Now, sharing is where you have either a multi-step process or concurrent powers. In other words, two different institutions, or in the case of federalism, two different sets of institutions, have the same power. One thing to note about sharing is that this is done for one, empowerment, so that the job can be done at multiple levels, as well as, again, for restraint, because now what we have is a bit of policymaking competition. So it's not so much that the two levels compete with each other check each other directly. It's that by competing, there's a kind of a boundary maintenance. So, for example, because both state and federal governments exercise the taxation power, there's a competition to be the primary taxing power. And when one level taxes a decent amount, that can crowd out the other level, and then that other level will want to push back. And so this is one of the dances that goes on in the American federal system. Largely over the course of the 20th century, the federal government's growing share of the tax pie largely squeezed out states from having taxation as a large source of revenue. And what ended up happening was that the states needed to rely on federal funding through grants to support a lot of their activities. And there was, in the last third of the 20th century, some pushback against the federal government from states' rights advocates, largely in the Republican Party, but also Democrats themselves want to make sure that states aren't fully crowded out. So the concurrent power of taxation that creates a bit of a competition, it can promote a sort of shoving back and forth to keep the boundaries of that power sort of in check. So the taxation power is in check, even though many people probably feel like they're being taxed left and right, because of this competition between state and federal governments. Now, multi-step processes are intentionally set up aspects of a system of institutional arrangement that provide direct checks on the power of one institution or one individual office holder. I'm just going to give a few examples because this is not, there's really no way to talk about multi-step processes except by giving examples, except to note that in democratic systems, many of the processes are multi-step. Electoral processes are often not just people vote and then somebody wins. There's often a multi-step process. That's true throughout the entire range of governance structures as well. So here are some examples drawn from the United States system. The appointment of judges and executive officials via the Senate. It's a multi-step process to put people in those offices. It's a selection mechanism, talked about it in Module 1, that involves appointment, but two different sets of office holders. In the case of judges and executive officials, the first stage of the process is the president makes an appointment, and then the Senate has to confirm those appointments. That's a shared power. Appointing judges and executive officials is not a power of the presidency. It's a shared power of the president and the Senate. Usually in these shared powers, there's the multi-step process is distinctly laid out, that one of the institutions or office holders will get to go first, and then someone else gets to go second. Now, in the case of the next example, executive veto and legislative override, there's a back and forth here. The veto is actually also part of the bigger multi-step process. It's a specific case of the multi-step process that in order for a bill to become a law, it has to be passed by a majority of both houses of Congress, which is already a two-step process because of the bicameral legislature. And then it has to either be signed into law by the president or vetoed and then overridden And so there is their sharing of the statutory power, the power to make laws, is shared by the legislature and the executive. And the bulk of the work is done in the legislature, but the actual ability to stop a law from going into effect with a veto means that the president has just as much power. One person in this case has just as much power as majorities in 2 houses of Congress. And then, of course, with the override, that gives that power back to the legislature, which has just as much power that the executive has over the final disposition of a particular piece of legislation. Though by setting the override at a 2/3 majority, it creates an obstacle in that process. And there usually are, in multi-step processes, there is some kind of differential decision-making criteria that are often escalating in difficulty or seriousness. So I'm going to jump down to the final one on the list, and I'll get back to regulatory power. Impeachment and removal is a 2-step process that's shared by the House of Representatives and the Senate that's different than the normal legislative process, which is also a form of shared power. But in the normal legislative process, it's a majority of the House and a majority of the Senate. And the real sharing that's going on there is between Congress as a whole and the presidency in terms of signing a law or vetoing a law. In case of impeachment and removal, each house has a special power, and there are differential levels of approval. Impeachment articles of impeachment can be passed by the House with a simple majority. And removal requires 2/3 of the Senate to remove. And that is intentional, and this is kind of a standard escalation of processes. Another example that I don't have here on the list, but it could easily go on there, and there are innumerable ones. I shouldn't say innumerable, they're numerable, but there's a lot of examples. Another one is the power to change the Constitution through amendment. That is a multi-step process shared by Congress as a whole with the states as a whole. And Congress, each house of Congress has to pass an amendment with 2/3 majority, and then 3/4 of the states. So it's not necessary in a multi-step process to have a kind of an escalating level of approval, but it is very common. And that's a good way of, 1, creating a check, but 2, sort of limiting the checking power, right? But by making it harder to do. And that tends to lead to restraint rather than empowerment. If you have an increasingly steep obstacle throughout a multi-step process, that is going to lean towards restraint rather than empowerment. If we wanted to make the U.S. Constitution easier to amend, then there would have been, say, simple majority in both houses of Congress and 2/3 of the states required to pass an amendment. If that had been the case, 1, we would get a lot more amendments proposed, because it's much simpler to get a simple majority in both houses of Congress than it is to get 2/3 majority in both houses of Congress. And then 2/3 of the states is obviously lower than 3/4 of the states. We would have for example, the Equal Rights Amendment would be part of the U.S. Constitution because 2/3 of states did in fact ratify it, but it didn't reach, just barely didn't reach the 3/4 of the states. Now, the example right above impeachment and removal, regulatory power, and I note that that's a revocable legislative grant to executive agencies. This is an interesting shared power that is a result not of constitutional design, but of political practice and a sort of bowing to necessity. One of the reasons why the executive branch has regulatory power, not just to implement, but to make policy, is that starting in the early 20th century, with the federal government taking on more roles in American society, like taking in more policy areas, the Congress recognized that it was going to be very difficult to make good policy in this expanding list of policy areas on an ongoing basis, and that especially among elected officials, especially with a bicameral legislature, which has 2 different election cycles, it was recognized early in the 20th century by Congress that Congress was not necessarily the most fluid, efficient policymaking machine. And so regulatory power was gradually handed over to an increasingly long list of executive agencies that had direct policymaking power. The first big one was the Federal Reserve, which resulted from the Federal Reserve Act of 1913, giving a lot of power to an executive agency to set monetary policy on kind of an ongoing day-to-day, week-to-week basis. Members of Congress knew that Congress was not going to be able to keep up with demands of a rational, effective monetary policy by voting on changes in, for example, interest rates and the speed of money and required liquidity and all the things that the Federal Reserve does. That was one example of what would become kind of a gradually increasing onslaught of executive agencies, the Environmental Protection Agency, the Federal Communications Commission. The list really just goes on and on of who has policymaking power in the executive branch. Now, it's concurrent power because basically the first stage is that Congress gives an executive agency a regulatory grant. They basically say, okay, you get to make policy in this area within these boundaries and then go. Now, it's revocable because at any time, Congress can either repeal a regulation, they can regulate the regulatory process itself, requiring certain kinds of steps in the regulatory process, which Congress has done at a couple of different times in regulatory reform. There are reporting requirements. There are ways in which regulations are temporary for a certain period and they can be revoked, or they're not temporary and it's harder to revoke them. So Congress still controls the regulatory process, but it is a shared power that can at any time be revoked, but in reality is not going to be, because there's just no way that all of the regulatory powers that the federal government exercises could be exercised in any effective way by the US Congress. Any elected body is going to be much slower moving than a body that's made up of political appointees. So that's a good example of a shared power that's not built into the Constitution itself, but has arisen from kind of necessity of changing times, and the political tradition is now built up. So not all institutional arrangements have to be in the constitutional system themselves. Some of them will emerge as practices that are engaged in through political experience, and the granting of regulatory power is absolutely one of those. Okay, the final concept in this lecture, the blending of powers. Blending is a way of breaking the boundaries of the traditional three-branch separation. And even if you look over at the model, right, you see it's a Venn diagram that overlaps. And as I indicated in discussing the traditional three-branch model and its relationship to the three-stage policymaking process, each of the branches kind of gets a little bit of power in a different box on the flow chart, as a way of kind of connecting these institutions in a way that creates more checks on each other's power. There are other ways in which the boundaries of the traditional three-branch model are broken up, not just for the purpose of checks and balances, but for the purposes of kind of effective, rational policymaking on different types of arenas. So here are some examples. Quasi-judicial bodies, in other words, judicial bodies that are within the executive branch. Why they're called quasi-judicial bodies is because they're not in the judicial branch, but they do what a judicial body would do. They hold hearings and they make binding decisions that are then appealable to usually an actual judicial body like the federal circuit courts. And if you think back to the model, the sort of complex multidimensional model from the previous lecture, the mediation boards are often quasi-judicial bodies within the executive branch. One good example is the National Labor Relations Board, which has binding power of mediation between employers and unions. Those decisions are binding, but they can also be appealed. So the National Labor Relations Board is a quasi-judicial body that could be in the judicial branch, but has been chosen to be put in the executive branch. And one of the reasons and kind of the dominant logic behind a quasi-judicial body is that it's a judicial body that requires a specific kind of policy expertise, and courts tend to be general purpose, particularly at the federal level. And that's because we really largely have, to reference back to the previous lecture, the simple integrated model of a judicial branch, so that courts are really multi-purpose. And when we're looking at specific types of judicial processes like mediating and ruling on labor disputes, it's a good idea to not just leave that in the hands of a general purpose court or to create a brand new court within the judicial system, but to draw on the policy expertise of the executive branch, which has a labor department already. And so the National Labor Relations Board has a sort of natural home within the executive branch. Another example that we have here in Portland is the commissioner system of government, where legislative and executive functions are unified in one set of office holders. So our city council members are elected to sit on the city council, which exercises legislative power. They make policy and they set budgets. The commissioners, the city council members are also commissioners who are the heads of the executive departments of the city government. The idea here, the original idea behind the commissioner system of government was to make sure that executive agencies were actually overseen by elected officials to avoid corruption and party machines. So the purpose there was specifically for checking power. Unlike quasi-judicial bodies, where the purpose there was for essentially empowerment, to make sure that these judicial bodies did a good job by coming from a specialized policy area, the commissioner system of government was actually less about efficiency and more about anti-corruption. One of the problems with the commissioner system of government is that it actually kind of gives up efficiency. We have general purpose elected officials, city council members, who are then in charge of city bureaus like the Police Commission and Parks and Rec and Department of Housing and Department of Transportation, and they aren't elected or appointed for their expertise in these particular areas. This is a good example of how blended powers aren't necessarily a positive thing. Or it's really a good example of how in all institutional design decisions, there are trade-offs. In the case of the commissioner system, trading off expertise for checking corruption. The third example is binding oversight by the legislature. And this is where essentially oversight is put into, binding oversight is a judicial type of function. And in the case of impeachment and removal, it's a judicial function, really. An impeachment trial is a trial, but it's conducted rather than by judicial officials, it's conducted by elected officials. And you know, we're seeing right now what the consequences of putting elected officials in charge of essentially a judicial proceeding, that members of the Senate are supposed to be jurors, but as elected officials, they're going to be thinking like elected officials. They're going to be making political calculations about their verdict rather than what we typically want jurors to do, which is to take a neutral approach and judge the case based purely on its merits. So this is another example, impeachment and removal, of where in this case it's both sharing and blended. I have the same example in two categories here. It's a blending of a judicial power judging in this case an accused crime, right? And even bringing charges, right? Articles of impeachment are equivalent to bringing charges, which is usually done by the executive branch. The prosecutors have discretion to bring charges, and then those charges are tried in the judicial branch. So impeachment and removal is a blending of what is traditionally an executive and a judicial power, bringing charges and hearing the case in the legislative branch among elected officials. The reason why the authors of the Constitutional Convention did this is, I think, because they wanted to repose sort of this ultimate really big power in elected officials, because the power was supposed to be seen really as close to the people. Impeachment and removal is really supposed to be a response of the people to bad behavior or corruption in government. And the idea was that instead of putting that in the hands of the judiciary, which is actually in our federal system, the most remote branch from the people, or putting it partly in the executive and partly in the judiciary, which would be problematic because the officers being impeached or capable of being impeached are mostly in the executive branch and the judicial branch. The idea was to put that power into a branch that is not involved in those controversies, but that is also then closer to the people. So one thing to note about sort of blending powers, breaking the boundaries of the traditional three-branch separation, is that there are usually specific and unique reasons to do so for a particular blended power, and it's not always that is going to have the best outcome. It's probably not we're not going to probably get a very just outcome from a Senate trial where the jurors are elected officials who are 50% of whom are from the party of the person who is being accused. If the Supreme Court were handling if the Supreme Court were the jurors in the removal trial, even though most of the justices who are sitting currently were appointed by Republican presidents, and even though 3 of the 9 were appointed by the very president who is up for the removal trial, because of their lifetime appointments and because of the kind of immunization of their office from political blowback, they would be more likely to look at the merits of the case and less likely to look at the political calculation. But that choice that was made by the authors of the Constitutional Convention to leave removal in the hands of elected officials was a specific choice. They did it for a reason. We now can see that the downside of that could be that it could be practically impossible to ever remove a president from office because of the politics, unless you had one party with a really dominant control. And even then, Andrew Johnson was facing a Congress that was dominated by radical Republicans, and yet they still fell 1 vote short of actually removing him from office. So that particular choice ended up with a blended process that really doesn't probably do very much. Now, this is one of the consequences of designing a system of institutional arrangements without a whole lot of experience with democratic politics, is that there's speculation as to what the trade-offs are going to be and what the best choice is going to be. Part of the problem with the U.S. Constitution is that it was written, as I've said a couple of times, before all of the ideas that we currently have about democratic forms had been developed. There was no such thing as proportional representation. There was no modern experience with a dual or multiple executive. And there, in addition to not having the full menu of choices, there was very little experience with democratic forms at all. And so the authors of the convention were essentially guessing as to what was going to work most effectively. I would say that their guess that impeachment should be put in the hands of the House of Representatives and then in the Senate probably fell short of what their desire for that particular mechanism would be, but it makes sense. Logically, it's not ridiculous to do this, to put in the hands of the legislature the power of removing officials from the executive and judicial branch. Now, this all just is a way of noting, too, that the traditional model is, in a way, I won't say it's arbitrary, but the mapping of each branch onto one of those 3 steps in the 3 main steps in the policymaking process is really just a kind of a categorical convenience. There is no necessary reason why you couldn't put various bits of the implementation power in the hands of the judiciary or the legislature, or various bits of the budgetary power in the hands of the executive. And in fact, the budget process that we have at the federal level does in fact start with a requirement that the executive branch submit a budget. And so even though that budget isn't binding in any way, it's kind of a wish list, sort of your letter to Santa Claus, it still is an important part of the process. So again, through political practice, we tend to see more sharing and blending than in the kind of much more strict traditional model, which underlies our constitutional system itself. Now, if you were devising a constitution from the ground up, you would, you would have a lot more options than were available to the dudes who were in Philadelphia in 1787. And there's a lot more experience, not just in the United States, but globally, with the different kinds of forms that are possible and available to a democratic system of governance. Okay, so I'm gonna leave this at that, because anything else I would say here is probably best said in the last lecture for this module.